Welcome, everyone. I'm Lisa Esquivel-Long, editor at KPC Media's Greater Fort Wayne Business Weekly, and I'll be your moderator for today's webinar. This is the fourth in a new monthly series that we're bringing free to subscribers. The topic of today's webinar is elder law, with presentation by Beers Mallers LLP. We want to hear what you're concerned about. So during today's presentation, please ask your questions by going to the Q&A section that you'll find on the right-hand side of your screen. We'll go over your questions periodically throughout the presentation. Here with us today are Jesica Thorson and Heidi Adair with Beers Mallers LLP. Welcome, Jesica and Heidi.
Thank you.
Thank you.
Hi. Please tell us a bit more about your background and what we'll be discussing today. So please tell us more, Heidi.
Okay, thank you, Lisa. Let me start out just by introducing our law firm. We're with the Beers Mallers law firm, and we are a law firm that is 20 attorneys strong, scattered around 3 different office locations. We have an office in Fort Wayne, one in LaGrange, and one in Warsaw. And we think of ourselves as a general practice law firm. We can deal with things ranging from business matters, real estate, litigation, municipal, virtually any issue you can think of. We have lawyers that can handle it. Jesica and I are in the elder law and estate planning section. Our goal for today's webinar is to help the viewers, consumers, understand the difference between an estate planning lawyer and an elder law attorney, and give you some ideas of what could be going on in your life, which would cause you to want one versus the other. We're going to walk through some basic estate planning documents, things that everybody should consider having. And then we're going to focus in on some specific elder law issues and helping you set up a framework for thinking about a healthcare plan for yourself as you go through the aging process. Now I'm going to tell you a little bit about myself. My name is Heidi Adair. I'm a Fort Wayne native. I graduated from Concordia High School and really only spent 7 years away from Fort Wayne while I was in Bloomington at IU, going to college, majoring in English, and then going to law school. While I was in Bloomington, married my high school sweetheart, and then we moved back to Fort Wayne and raised our family here. We have 2 adult children. One lives in Chicago, one lives in Indianapolis. I wish they both lived next door to me, but that is not in the current plan. Upon my arrival back in Fort Wayne, I landed at Beers Mallers and have spent my whole career there. I've been working at Beers Mallers for 27 years. And most of that time I've been in the elder law and estate planning section. It's work that I absolutely love and enjoy. I've had the privilege of meeting wonderful individuals and families and helping them work through some, good situations and difficult situations. So that's a little bit about me. I'm going to turn it over to Jesica Thorson. She's going to tell you a bit about herself and then jump into the meat of the material.
My name is Jesica Thorson. I have been with Beers Mallers for 14 years. Like Heidi, I have only ever been at Beers Mallers for my legal profession. I went to the University of Montana for my undergrad and then went to Thomas Cooley Law School in Lansing, Michigan. I was away for about 10 years before coming back to Fort Wayne, but I did my internship with Beers Mallers my last year of law school and fell in love with not only the firm, but fell back in love with Fort Wayne. And so my husband and I moved back to Fort Wayne and we've been raising our kids here since. When I first started out at the firm, I did a little bit of everything as far as areas of law, but quickly realized that elder law was where I really wanted to be. I love this area of law because I get to work directly with families and I get to walk them through some really difficult times in their lives. So I'm excited to talk to you today about what an elder law attorney is and why you may want to consider using an elder law attorney. So a lot of times when I refer to myself as an elder law attorney, I get some strange looks like, what does that even mean? Or someone will say to me, you know what, I'm not old, so I don't need that. And what I like to always respond to that is, well, an elder law attorney isn't just for the elderly. It really is for everybody. An estate planner is an attorney that is going to focus their practice primarily on drafting wills, trusts, power of attorney documents. They may do a little bit of guardianships, and they may also do some tax considerations as far as gift or estate tax planning. But an elder law attorney is not only going to do all of those areas of law, but they're going to do it with the mindset of thinking about Medicaid benefits or VA benefits and how to stretch out your dollars for your family to meet all of your estate planning goals and provide for your care costs during your lifetime.
I'm going to start out just with a little bit about the planning process, because I think people generally are very nervous to to even phone a lawyer or email a lawyer. So let me tell you what to expect. When you phone into Beers Mallers or email, you're likely going to be put in touch with one of our paralegals or legal assistants. And they're going to work with you and ask you a couple questions about what's going on in your life. Are you a young person who is just needing their very first basic will? Do you have young children? Do you want to set up a trust for your kids? Do you want to name who would be the guardian for your children should something unfortunate happen? Are you in the middle stages of your life where you want to figure out the most efficient way to pass your assets on to the next generation? Are you worried about incapacity issues? Do you need guardianship help? Are you worried about long-term care issues? So after they kind of help figure out where you're at in your life, they're going to generate a questionnaire that they'll either email to you or put in the mail to you that asks you a lot of questions about what's going on. The types of things that our questionnaires generally ask are what's going on with you? How old are you? What's your health like? We ask about your family. We ask about your income and your assets. It's a quite lengthy questionnaire, but I say don't let the length of it keep you from coming in. Do your best to fill it out. And if you bring a decently completed questionnaire to the first meeting, we can have a very productive meeting where we can walk through that, help you identify what possible goals you might be most interested in trying to take care of. And then coming up with an action plan going forward of we're going to do this at the next meeting, this at the following meeting. These are the things that you still need to follow up and get more information on. So, and 95% of the time, we can tell you about how much it's going to cost to do the planning that you're going to do. Sometimes it's impossible. We just don't know how long or how difficult it's going to be to work through the process. And we will let you know that usually at that meeting. So that's a little bit of the planning process.
So we get asked often about what are the basic kind of estate planning needs or documents I should consider. And you'll see on your screen that this list here is truly the basic plan that Heidi and I recommend to really anybody over the age of 18. It's going to include a power of attorney, more specifically a durable power of an attorney, as well as an appointment of a healthcare representative. And then a will, or maybe a trust, depending on the circumstances. Sometimes we'll do both. And then also a living will, because the living will give some directions to your family about your care plans. So a living will is a document that provides directions to your loved ones about what you would want to happen if you were in a prolonged vegetative state. This document provides you with choices on what you would want to happen in regards to hydration and nutrition if you were in that situation. It is a situation where a doctor certifies in writing that you have an incurable disease or illness, that your death is certain to happen in a short period of time, and that the use of life-prolonging measures is delaying the natural dying process. And so you can see this is a very complicated document, and it's a very difficult emotional choice to make. So this is something that we usually encourage people to talk about with their families before they come to our meeting, so that they kind of are aware of what it is that they would choose when signing. The other document that we will often recommend when it comes to a living will is a post form. And this is a legal document that can also provide treatment preferences and make sure that those are honored if you were in a terminal illness situation. However, this is a document that needs to be signed by your doctor. What we recommend is that you set an appointment with your doctor in order to go over the post form, especially if you've been diagnosed with a terminal illness such as cancer or Alzheimer's or some other progressive illness. But this document is a great tool because you can really make choices about antibiotics, artificial nutrition, as well as hospitalizations, intubation, and resuscitation. So this is a very all-encompassing document, and it really does take a whole appointment with your doctor to make sure that your needs are being met. Because depending on what is going on with your health, your thoughts about this may change. At some point, your desire for antibiotics may stop, and that may change the course of your treatment. And so this is a long meeting with the doctor to make sure that you are getting all of your preferences honored. In addition, there is some new healthcare power of attorney laws that are taking effect starting July 1st. The reason that Indiana has changed their healthcare power of attorney documents is because we've had the same laws, believe it or not, for 30 years. And so there have been some conflicting statutes when it comes to who you can appoint as your appointment of a healthcare representative, as well as what type of treatment you can really decide in this document. Traditionally, our documents, you really just said who can make those decisions for you in a situation. You didn't really get to decide, okay, if I was in a car accident, I want you to do X, Y, and Z. If I was terminal cancer, I want you to do X, Y, and Z. And so the new change in the law is allowing you to do that. So there are two really great websites that I encourage you to visit, because these are things that we will begin talking about with our clients to make sure that when we're drafting these documents, that you have considered some of your choices, and so that we can make sure that we're drafting the documents appropriately. So the two websites that I recommend, luckily they're easy to remember. One is simply 5wishes.org, and then the other one is prepareforcare.org.
All right, so I'm gonna keep going here talking about powers of attorney and guardianship, but just to give you all the, go back to the previous slide, to give you all the heads up, we're gonna pause in a few minutes to see if there are questions. So if you've got questions on material that's been covered so far, please feel free to put them in the chat box. So another very important document
Sorry,
is—
go ahead and put them in the Q&A box. So
Oh.
yeah, I don't see any questions yet. I think people are mulling over this information, but please, just go ahead and put your questions in there. Thanks.
Okay, great. The other document that a person should really consider is a financial power of attorney. And the financial power of attorney is one that allows you to say who is going to make financial decisions for you, handle your finances if you're incapacitated, not deceased, incapacitated. And we're going to kind of try to get everybody clear in their minds who does what while I'm alive and who does what while I'm deceased, because there's a lot of confusion on that issue. So the financial power of attorney is who can handle your finances while you're alive and sick. And there are some things to think about. So sometimes you've got what's called a springing power of attorney. And that is a power of attorney that only takes effect after a certain test has been met, such as 2 physicians have certified that you're incapacitated. Now, that sounds like a great idea. I'm going to protect myself from somebody taking my power of attorney and doing something that I don't want them to do unless my doctor says that it's okay, which sounds great on paper. But practically, I try to encourage clients to not use the springing power of attorney, because you can imagine you're sick, your chosen person is dealing with your illness. They're trying to figure out how to use the power of attorney. They find time to get to the bank with the document, and the banker looks at the document and says, "Oh, I can't help you until you get me 2 doctor's notes." And we all know how difficult it is to get notes from doctors. So you work through that process. Then 3 or 4 months go by and you need to do something else, and you show up with your power of attorney and your 2 doctor's notes, and they say, "Well, these notes are too old. Could you go get me new ones?" So while it sounds really like a wonderful precaution to take, it really creates a lot of red tape and hoops to jump through when you're in the middle of a crisis. Now, you may have a situation that you need that level of protection, but just know when you're considering how you want to structure your power of attorney that you're adding layers of red tape for when the need arises. Generally, I try to steer my clients to just a durable power of attorney, one that takes effect right when you sign it. For example, I have a durable power of attorney naming my husband. I have, great faith that he's not going to do anything that I don't want him to do. So if I'm gone on vacation or I'm working on cooking something for dinner and he needs to go handle something at the bank, he could do it. I find that that's the most easy and convenient way to structure your power of attorney. Other things to think about, you want to name somebody to do it and you want to name a backup. We've run into situations where we've seen people only name one person as their attorney, in fact, and that one person themselves has died or becomes incapacitated. You, as the person who set the power of attorney up, has become incapacitated, so you can't sign a new one. So we're in a situation where we really have no one available to act. So think about naming somebody as well as naming a backup. I want to talk to you about the difference between having an and situation set up or an or situation set up. And I'm going to use the example of my kids. So let's say that I have named my husband as my primary power of attorney and my children as the alternate. And if I've got it set up that my alternates are Aaron and Jack, it would require both Aaron and Jack to do everything together, which again, might sound like a great idea, but one of them's in Chicago, one of them's in Indianapolis. They're probably going to flip a coin and say, who's up to go help mom this week? And so whoever has the most time in their schedule, who's got the most convenience, can come and help would be the best way to set it up. So I would want it to be Aaron or Jack. The and situation, which we do run into when we are reviewing people's documents, again, is another level of red tape and inconvenience that you have to work through. Again, maybe your family needs that type of protection, but be very intentional if that's what you want to do. And the other last little tidbit on powers of attorney that I'm starting to just learn because I've been working with people now for quite a while. In the old days, it was just a no-brainer for me. I would name a person's spouse and some combination of their kids or other, important people in their lives as the alternate. And now I'm finding that my clients are getting to the point where maybe the spouse is too frail to get out and transact the business that needs to be done as the power of attorney. And I'm finding that it's much easier to have the spouse or the children or the other important people in their life all at the same level. Because when the spouse gets too frail, we got to drop a resignation paper or get a doctor statement as to why the spouse can't do it so that the backups are able to do it. So as you age, you may want to consider putting your backups on the same level as your first named ones. So the reason that we're camping on powers of attorney so much is that doing a power of attorney is something that's very inexpensive to do, or relatively inexpensive to do. And if you don't have a power of attorney in place, the alternative is to go through the court system to have a guardianship set up. And a guardianship involves the person who wants to be named as guardian hiring an attorney. The court will appoint another attorney called the guardian ad litem to go and interview or speak with the person who's incapacitated or sick. It involves petitions being filed with the court testimony being given, accounting to the court of all of the income that the incapacitated person brings in each month or each year, all the assets of the incapacitated person, possibly posting a bond, which is basically buying an insurance policy to cover the value of the incapacitated person's assets in case the guardian abuses authority and steals them. And then accounting to the court every year, every other year about all of the financial activity within the guardianship. So you can see this is a process that's going to take quite a bit of attorney time. And when attorneys take time, it costs money. So it's a much more expensive, stressful process to have to deal with a guardianship than if you've got a power of attorney. In fact, my kid's 18th birthday, their first stop was to my office. Hey, sign this document. You just never know. And just because I'm their parent or just because you're someone's spouse does not give you access by relationship to be able to perform those functions for them. All right. So let's now switch on to thinking. Oh,
we do have a couple. Well, one thing that people, Kelly and John in the Q&A would like to know is, Jessica, if you could repeat those two websites, particularly, was it 5 wishes and is 5 spelled out? I just want to double check on that.
Yes, 5 is spelled out. I apologize for that. So it's 5wishes.org and the word 5 is spelled out. And then the other one is prepareforcare.org, all one word, lowercase. Prepare for FOR care.
Okay, all right. And that's all we have so far, so go ahead.
Okay. All right. So let's talk about planning for your final affairs. And I like to spend a fair amount of time on this because it's something that people get very confused about. So most people are familiar with a will, where you create a will and you name a personal representative or executor who is going to handle the payment of your bills and the distributing of your assets when you pass away. So that is something that most people are familiar with. They do a will and think that they've taken care of everything. But there are other assets that it doesn't matter what your will says. It matters the contractual arrangement with those assets is what trumps how that asset is going to be distributed when you pass. And the first type of assets I want to talk about are assets that have a beneficiary designation associated with them. So think about your life insurance or annuities or IRAs or 401ks, or even payable on death arrangements at a bank. Those are all situations where you have filled out a piece of paper that says who you want to get that asset when you pass. That is a contract between you and the holder of that asset as to what the holder of that asset is going to do with that asset when you pass away. Doesn't matter what your will says, doesn't matter what your trust says. If your beneficiary designation says something, that's how it's going to go. So I really advise that people every 5 years, 3 to 5 years, you sit down and look at your will, make sure it says what you want it to say, and follow up with the people that you've got beneficiary designations on file with. Ask them who is your beneficiary so you can be sure that the paperwork that they have matches what you want. I've run into many situations where a major life event happens and people don't think to update their beneficiary designations, such as additional children being born, divorces happening, remarriages happening. And at those times, it's very, very important that you update your will and also update your beneficiary designations. The other type of way that property can pass at your death is through joint ownership. So if I've got a bank account that I own jointly with Jessica, and I've put her on that bank account because I know she's going to help me out, and I don't want to make her have to take her power of attorney into the bank every time. When I die, I probably have a will that leaves everything to my husband and my kids. But because I've added Jessica as a joint owner of my bank account, she's going to get all the money. And I know Jessica, she may or may not give it to the people who I want it to go to. So be very careful about joint ownership. And where I see people kind of slip up on this, just they're living their life. Maybe they're in a second marriage and they've got a will where both parties in the second marriage have said, we want things to go to our kids that we had before we were married. But they settle into life and they open a joint bank account. Well, that joint bank account is going to go to the survivor of the two of you. It's not going to go to your children. You buy a house together. You just do it. You just don't even think about it. Through the process, all of a sudden you own the house jointly. It's going to go to whoever survives the longest. And then that survivor has a will leaving to their own children. It doesn't include the other children of the person who died first. So you've got to be very careful about joint ownership as well. Trusts. Let's talk about what a trust is. So a trust is an arrangement between 3 different parties. And I think about a trust kind of as a bucket that has 3 people holding up the bucket. The first person who participates in the bucket is the grantor, settlor, maker. That's the person who sets up the trust, the rules of the trust, and says, this is my trust and this is how I want it to run. The second entity involved with the trust is the trustee. And that's the person who does what the maker tells them to do. They're the ones implementing the rules of the trust. The third layer is the beneficiary, and that's the person who benefits from what's in the trust. So often, there's many uses for trust, but I'm going to talk mainly about the revocable living trust that a lot of people have heard of. So what a revocable living trust is one where, like, I might set it up. I'm going to be the maker, I'm going to be the trustee, and I'm going to be the beneficiary. I'm going to be in complete control of that bucket while I'm alive. But I'm going to say who's going to take my place as the trustee when I'm gone or sick. And I'm going to say who's going to take the assets from the trust when I'm done with them. Who's going to be the next level of beneficiary. So I've died. New people pop into the roles that I just discussed in the trust. But the trust itself didn't die. And because the trust is ongoing, the people who are administering the trust, wrapping it up, making sure the bills get paid, making sure the new beneficiaries get the assets, don't have to work through a court system, which saves a little bit of time, a little bit of money, and just allows things to go a little bit more smoothly. So some people opt to use a trust versus just a will to pass their assets. But a very important part of the trust working is having the trust properly funded. So things that don't have a beneficiary designation on them or aren't jointly owned, we want to make sure get into the trust. So we create, our way of doing it, we create a spreadsheet. What assets do we have that need to go into the trust? What assets do we have that go by beneficiary? So we very intentionally make sure things are organized the way that they should be in a trust situation. The other big issue that a person should think about is if they have a person in their life who has special needs. Oftentimes, person's natural inclination is, if you've got a special needs person in your life, you want to just make sure they've got maybe more than the other person. You want to make sure that they are rock solid, absolutely taken care of. So your gut reaction may be, you know what, I'm going to leave Johnny 80% of my asset and my other family members 20%, because you want to make sure Johnny's going to be okay. Well, if you leave it just to Johnny, we can kind of help salvage it, but it's not as good as if you create a trust for Johnny that is called a special needs trust. And this type of trust has all kinds of, I call it magic language when I'm explaining it to clients, that says this asset in this trust is to be used to supplement the needs of Johnny, not replace governmental assistance benefits such as Social Security or Medicaid. And by having that magic language in there, the Social Security Administration, the Medicaid organization will look through the assets in that trust and will not count them against Johnny's qualification for these benefits. And so that safety net that you really want to accomplish for that person is there, and the assets in that trust will not be needlessly spent on housing expenses, healthcare expenses, that there's a governmental program that can take care of those. So if you're in a situation where you've got a special needs person in your life, be sure to take that extra step of preparing the special needs trust. All right, let's take a little bit of a look at the federal estate tax situation right now. So when I first started practicing law, a long time ago, the federal estate tax exemption was $600,000. So we all spent a lot of time worrying about federal estate taxes because it impacted people. $600,000, it grabbed a lot of people. Over my 27-year career, it's been steadily growing. And 5 years ago, it was at about $5.5 million. A couple of years ago, 5 years ago, it shot up to $11 million. And that number has continued to go up with inflation. So here, as we sit today in 2021, the federal estate tax exemption is $11.7 million. So if you're married, the husband gets $11.7 million, the wife gets $11.7 million. So between the two of you, you can pass along, $23, $24 million with no federal estate tax. So that does not, the federal estate tax is not impacting that many people in the world today, in the United States today. $24 million gets it done for most people. You may be aware that there was a lot of talk during the election of lowering the federal estate tax exemption down to, I heard, as low as $3 million. That talk seems to have quieted. In January or February, I was getting 4 or 5 emails a day from various, educational institutions teaching us all what to do to dump money before the rules changed, because it just seemed it was happening. That talk seems to have quieted now. I don't know why. Maybe they've said to themselves, oh gosh, everyone's getting rid of all their money. We better stop them. We better be quiet about what we're going to do. I don't know. Or maybe, I don't know. Maybe they just decided to not worry about that for right now. So seems to have quieted for now. But I would encourage people somewhere between $3 million and $12 million. You're the people who really want to kind of pay attention to the news and keep your eye on what's going on. The $11 million, though, is set to sunset in January of 2026, back down to 5. So we're all over the map. Who knows what's going to happen, but at least you kind of know how little we know. You know what we know at this point. So any estate planning questions out there? Because we're going to kind of switch topics at this point.
We do have Mike. He did ask, how does a real estate trust work for my home?
Okay, so a real estate trust generally is what's called a qualified personal residence trust, a QPERT. And what you do is you form a trust and you put your home into the trust. And you say that during the term of the trust, and it's usually 10 years, 20 years, something like that, I get to use the home. But at the end of the period, when I'm done using it, my home is going to be distributed from the trust to my children. And if I want to keep using the home after that, I'm going to have to pay my kids rent to do it. And why people do that is if you just give your home to your children, you go get an appraisal, what's the value of the home today? And that's the value of the gift that you've given. But the fact that you have retained the right to use the home for a period of time, there's actuarial tables that help figure out that value of the gift to the children really isn't the full value of the home because they don't get it the next day. So you get to discount the gift that's given to the children. So that's a big thing. When you're trying to give gifts and save taxes, you want to, get money out of your estate at the lowest value that you can. But you do have to be aware that eventually payday comes where the kids do own the home. And if you want to use it, you need to pay rent to them. So hopefully that answers your question.
Okay. Yeah, that's the only other question we have. The next question, they are interested in nursing homes. So that's
okay.
Where we're going next. So
we'll jump in. So as Heidi mentioned, up until now, we've really been talking about estate planning issues and why you would contact an estate planning attorney to talk to them about those particular documents. But now we're kind of jumping into elder law. And really the things that we're going to talk about over the next few slides in the next half hour or so is really why you would want to talk to an elder law attorney. These are concerns and questions that we get on a daily basis. Usually what happens is we'll see kind of one or two different types of people. We're going to see the kids who have come home from a holiday or some sort of birthday celebration and have realized that mom or dad have really been coping really well when they've talked on the phone or when they've FaceTimed. But now that they've been living in their space with them for a weekend or a week vacation, they're realizing that mom and dad really are slipping a little bit more. And we're starting to need maybe a little bit more assistance than we ever thought or dreamed of. And so the kids are coming to see us to see how we can help mom or dad through that. Other people that we will see are actually mom and dad, and they're recognizing that they're needing more help maybe with their spouse, or they themselves are starting to worry about their care in their home, that they're seeing that they just need something more than what they currently have, but they don't necessarily know what that is. And so most elder law attorneys are going to spend a very, very long time talking about your daily routine and talking about what help you need at home. Do you need help getting dressed? Do you need help bathing? Maybe it's just cleaning that you need some help with, or some meal prep and organization. So we really spend a long portion of the meeting not only going over the questionnaire and the assets that Heidi mentioned earlier, but also just talking about, just tell me about your routine and your day and how you're getting along, because that tells us where we are in the process and how we can help you along this journey. And so a lot of times I will suggest things that are pretty simple that people don't always think about. Sometimes maybe it's modifying a home right away. You know, when a kid comes to visit us, we'll say, well, maybe what mom and dad need is no more carpets, no more rugs. And we have to start thinking about some modifications to the home. Maybe we need grab bars. Maybe we need to modify the bathroom. And we're looking at those type of care alternatives. Sometimes it's not necessarily a modification to the home. Sometimes it's just having a cleaning person come, or lawn services, or a handyman. There's just things that keep breaking on the house, and we don't want mom or dad to keep trying to fix it themselves. And I live in California, so we need to hire somebody that we rely on. And as the child, I will help set that up, and maybe I'll be present for that. And sometimes that's enough to get us through the next few months or the next few years, depending on the circumstances. Sometimes it's being a little bit more systematic with the family. If you've got 5 kids, maybe it really is creating a family schedule of, okay, who's going to take mom to the grocery store this week? Who's going to go walking with her at the Y? Who's going to go to Bible study with her? And just being very systematic so that we're getting the socialization that we need, and that we're really keeping an eye on the situation to see, okay, do we need more direct assistance with things like bathing and dressing and medication management and meal preparations and things of that nature. So we really do spend a lot of time talking about where are we at just as far as what we need in care. So a lot of times we'll encourage families to consider these alternatives. As Heidi is aware, not all families get along. And so sometimes we have to start thinking about other sources of care. And that is when we start talking about home health care and assisted living and long-term care. This will naturally lead to questions of how can we afford this? And as Heidi mentioned earlier, you know, getting yourself organized at this stage is the most important thing, not only from an estate planning perspective, but for care costs. If the more we know about your assets, where they're held and how much is there is very important. So a lot of times people are surprised to learn that when they look at their income from investments, as well as from their income in Social Security and pensions, that they oftentimes can afford some of the assistance that they need, that they need at home. A lot of times families will realize that really all that they need is a few hours a week, maybe somebody coming in 2 or 3 times a week to help with bathing, to help with just some meal preparation and light cleaning. And between their investment income and their Social Security and their pensions, they will have enough funds to pay for those without ever really touching the principal part of their investments. And so sometimes we start with just that. Other times we recognize that we need more than that light care, and we have to start looking at whether or not our principal in our investments is going to sustain us. Some people are surprised to find that they are able to self-pay, and that they may be able to self-pay for far longer than they ever dreamed that they could. So these are long conversations that we'll have with not only ourselves in our conference, but also with the financial broker. We really like to make this a team effort to make sure that we are meeting your needs, as well as thinking and planning for the future, because unfortunately we don't have that crystal ball, and we never know how long somebody will be able to stay at home. So then at some point, sometimes the income is just simply not sufficient to cover the care costs. And that's when we will start talking about Medicaid and VA benefits. But before we even get to that, a lot of times we'll get to the long-term care insurance. And so most of these policies are going to have some sort of provision that the policy will pay for either home health care needs or assisted living. Generally, there's going to be an elimination or an exclusion period. And what that really means is that for a period of time, you're going to have to pay for the services that you're receiving privately, whether that's a home health care aid or assisted living or nursing home. We see anywhere from 60 to 120 days. A lot of them are typically somewhere around 90 days though. And the reason for that is because, as a lot of the viewers may be familiar with, Medicare has what they call 100 days. 100 days of where they will pay for room and board at a rehab or a long-term care facility. So the long-term care insurance is usually tied to that, so that as soon as those Medicare days are over, then the long-term care insurance can kind of kick in. There usually is a daily limit, though, to these policies. So it could be anywhere from just $100 to maybe $200 a day for long-term care facilities. For assisted living, it's usually considerably less because assisted living costs are lower than nursing home costs. Also, some policies will have a rider that will adjust for inflation. So we've seen policies that were purchased in the 80s that are still very applicable today because of that inflation rider. Now, Indiana also has what they call the Partnership Act policies. Now, this is a new change that is just coming into the law as well. So technically what a Partnership Act is, there's two different types. There's dollar for dollar and there's total asset. And what this means is that when a person initially purchases the coverage, they're going to look at whether or not it meets the state limit for the daily minimum. I'm probably not explaining this the best, but what it is, is those purchasing coverages less than the state set dollar amount. For instance, in 2021, the state set dollar amount is $115. So you have to purchase insurance for at least $115 a day in order to get dollar for dollar protection. And what that means is after the policy has paid your dollar for dollar protection, say $150,000 total, you get to protect $150,000 of assets and still qualify for Medicaid benefits. But Indiana also has a total asset protection, which the 2021 limit for that is a policy that is in the amount of $430,000 or more. So this is a very much larger, more expensive policy because you are looking for total asset protection. But what that means is after the policy is completely paid, even if you still had $500,000 or $1 million in your bank account, you would still be eligible for Medicaid benefits. The big change, though, is that Indiana is doing away with total asset policies. And they're grandfathering on all the ones that are currently in existence. So if you have one, don't panic. It is still valid and it will still be honored. However, we're not going to be selling new policies. And because of this, the insurance companies have been seeing this change coming in the horizon. And so what we have noticed is a lot of clients coming to us with a universal life insurance policy that has a rider on it to cover long-term care costs. All kinds of different products out there. And so generally speaking, if you're getting encouraged to purchase such a product, what I would encourage you to do is not only have a meeting with an elder law attorney at that time, but also talk with your broker to make sure that really is a fit. Because we want to do that analysis of, can we self-pay? Do we have to consider Medicaid? Are you a veteran? And we want to make sure that we're buying the right product for you so that it is going to work for your long-term goal plans.
Can I just interject one
please.
thing? So if you are a person or your parents have a long-term care insurance policy, I'll find people, not too thrilled about a $2,000 a year premium. Just come meet with somebody before you think about canceling that policy, because there's a reason that the policies that were sold back in the 80s and 90s aren't being sold anymore. It's because the life insurance companies ended up to be the losers on those policies. So if you happen to be the person who bought one of those policies, be very educated in what you have before you cancel it, because 99% of the time we're going to say you are sitting on gold bars right now. Do not cancel that policy. In fact, call the insurance company and add somebody as a trusted contact so that if you forget to pay your premium, someone else knows about it so that they can make sure that premium gets paid.
Do we have any questions at this point?
I don't see anything, does anybody, I don't see anybody typing anything yet. So if you want to move on to the next part.
Okay. So we've really kind of focused on some more home healthcare, a lower cost type of situations at this point. So let's start talking more about planning for institutionalization, planning for a long-term care facility. And right now in Allen County, we are seeing anything from $7,500 a month to $10,000 a month in long-term care costs, depending on the level of care that a person may need. And so that's going to quickly deplete most people's savings. So over the next few slides, we're going to talk about kind of big picture when it comes to VA and Medicaid benefits. Our hope is to dispel some of the common fears as well as just some misinformation. Generally speaking, when people come to our office to talk to us about this particular issue, they right away already have heard some things or heard a horror story. And so a lot of our meetings is really just trying to reassure you that we can still do planning, that it's never too late to start planning. And so let's talk about pre-planning costs and what it means when people talk about a look back period. Generally speaking, I don't know about you, Heidi, but as soon as somebody comes into my office, they're like, well, I know I can't do it because there's that look back period. That's the first thing out of their mouths. And so just to clarify, there is a look back period for the VA. This is a 3-year period. And for Medicaid in Indiana, it's 5 years. And what that means is when you make your application, VA and or Medicaid will ask about any transfers that you have made prior to 3 years or 5 years to that application. So in other words, if you gave $5,000 to your granddaughter for college expenses 3 years ago, this is something that you're going to have to disclose to Medicaid when making that application. That doesn't necessarily mean that all is lost. That doesn't mean that your granddaughter is going to have to try to fork over her college money back to you. It doesn't mean that they're going to put a lien on your house or that you're going to garnish your bank account. And we'll walk you through some of that as we go through this. But it does mean that sometimes there is a period of time where Medicaid will not cover benefits for you. And so with that kind of in mind, we start to talk about how can we pre-plan and how can we look to avoid that situation. And so oftentimes people want to talk to us about trusts. And so far, Heidi's talked to us about revocable trusts. Really, when we're looking at a Medicaid situation, a revocable trust does not provide us protection because, as Heidi mentioned, you can revoke it, you can amend it, you can make whatever changes, and you're in the driver's seat. You get to control all of those things that are going on with those trust assets. So when it comes to pre-planning, we're talking about an irrevocable trust. And what oftentimes elder law attorneys like to use is what we call an intentionally defective grantor trust, which to me always sounds like a bunch of legal mumbo jumbo. And so the best way to explain it is yes, it is an irrevocable trust. Yes, you're going to be giving up control as far as trustee. You would not be able to be your own trustee, and you would not be a beneficiary. But the reason it's intentionally defective is for a couple things. If I needed to get all of the funds out of that trust in order to qualify you for Medicaid sooner than the 5 years than we thought, our crystal ball didn't work out and you need Medicaid help sooner. Well, we can remove all of the funds from that trust. Takes a little bit of legal maneuvering, but we can get all of the funds out. But the other reason it's intentionally defective is, as Heidi mentioned with revocable trusts, the reason people like to do that is to avoid probate, but also to maximize tax benefits. And so what we do with these irrevocable trusts is we continue to make it a grantor trust, and we continue to maintain all of those tax benefits that you get in a revocable trust. So the legal mumbo jumbo is actually really important because it does save your family, not only in taxes, but it helps with this pre-planning situation. A lot of people will consider to do a trust versus gifting outright to a family member. And this all will depend on the circumstances of the family. This kind of goes back to those initial conversations of what care do you need? Tell me about where everybody's living. Tell me who's involved in your day-to-day life. Because sometimes gifting to family members is the right choice, and sometimes gifting to family members isn't the right choice. A lot of times families will choose the trust because no one really owns the assets in the trust other than the trust itself. The family members are simply the trustees. They don't personally own those assets. So it's not commingled in their life. So if you gave a gift outright, if I gave it outright to Heidi, and she's in a terrible car accident 2 years from now that she caused and she gets sued, she's holding my money, which is now involved in that lawsuit. And so the trust protects from that, because even if she was my trustee, she doesn't technically own the funds, the trust does. And so it's protected from that situation. It's the same with divorces. It's the same if you were going to go apply for college loans or other types of loans for a second home. If the family member owns it, they have to disclose those assets. So sometimes it is the right choice to gift to a family member. Sometimes it's not. And a lot of times we will steer families towards the trust. It all depends on the family dynamics and what our goals are. There are a few gifts that are considered exempt. And these are very specific situations. And so it's one of those things where you really got to mention this right away to your elder law attorney, because these are tools that we're trying to use every chance that we can get. And so one of the exempted gifts is to a disabled person. And really it can be a granddaughter, it could be a child, it could be a nephew that you want to provide for. And generally speaking, when it comes to gifting to disabled children, as Heidi mentioned with supplemental needs or special needs trusts, sometimes it's okay to gift outright to them, but for the most part, we're going to try to use these trusts because we want to make sure we're not interfering with any of their benefits. One of the other gifts that you can make as an exempt gift is a gift to a caregiver child that has taken care of you for more than 2 years. You can give the home to them if they have cared for you for more than 2 years and that care has kept you out of a nursing home. It usually will require the involvement of a doctor. So if you're starting to think that this may apply to your situation, I really encourage you to really start being present at those doctor's appointments so that the doctor can see that you really are the one providing care, which can be tricky depending on your parent. Sometimes the parent is willing to let you come into those doctor's visits, sometimes they're not. But the sooner you can kind of start establishing that relationship and establishing that your care is really keeping you out of a nursing home, we can use this exemption to gift the home to that child. The other exempt gift is funerals. And this has changed a lot over the years. It's certainly changed over the last 14 years of my practice. It used to be that you could buy everything you could think of for your child's funeral, which always sounded a little creepy when I explained it to kids, because whoever thought to give the gift of a funeral to a child? But really, it is an exempt gift that you can do for Medicaid purposes. Medicaid has changed it a little bit, and so the gift of the funeral is a little more limited than it was before. So if this is something you're considering, it's definitely a conversation to have with your elder law attorney.
Great. I'm going to talk a little bit more specifically about the aid and attendance program, the Veterans Assistance Planning. So this is a program that's available to veterans or spouses of deceased veterans. And it is designed to help pay for healthcare, whether it be home care, assisted living, or nursing home care. So one of the criteria for qualifying for this program is that the veteran needs to have been in active military service for 90 days, with one of those days during a wartime period. And I've listed what the wartime periods are on the slide. And you can see, unfortunately, much of the last, 50 years, 60 years, we've been involved in various wars. So for a lot of the people who are reaching the age where they need a little extra care, there's a good chance that they did serve in the military during one of these wartime periods. As Jessica said, there is a 3-year look back for accessing the aid and attendance benefit, and there are asset levels that have to be met to access them. And the current numbers are you need to have less than $130,000 of non-exempt assets. And the exempt assets that you might have are a home, which they describe a home as a 2-acre piece of land, and a car. So if you've got a home, a car, and less than $130,000 and served during a wartime period, and you're a veteran, you could access up to $2,100 a month if you're married to pay for healthcare costs. If you are the surviving spouse of a veteran, that number is about $1,200 a month. So you can see it's a very potentially helpful benefit to help keep you in your home longer or help you be able to afford assisted living. So that's where the 3-year look back comes in. If you come to us and say, I want to talk about long-term care, I have no idea when I'm going to need it, but I know I was a veteran and I would qualify for this program, but you have too much asset, we might look at ways that we could fund a trust with your excess assets so that in 3 years, we would be able to access that aid and attendance program. It can be very helpful. One of the disadvantages of the VA aid and attendance program is that you actually have to incur the cost before you apply for the benefit. And it can take, 4 to 6 months to get an approval notice from the VA where you start to see benefit money coming in. So Sometimes what we will do in that situation, because a lot of times the people who want the VA really can't afford to pay for home health care at that time, is that we can pay a child. The Medicaid program does not allow you to pay, you have to pay a licensed caregiver. The VA program allows you to pay a child or anyone else who can help you. So sometimes to get through a rough patch, we'll pay a child who will then gratuitously make sure that your utilities get paid and your, medicines get bought. And then when the big VA back payment comes in, covering all the months that it took them to process the application, we can then repay the child for the money that they advanced you to cover your living expenses. And another good thing with the VA is that you need to meet level of care, but it looks more in the area of you needing help with 2 activities of daily living. Medicaid, you need to have help with 3 activities of daily living. You need to be sicker to get to the Medicaid program than you can be to get to the VA program. So can be a very helpful situation for people. All right, let's talk a little bit about Medicaid waiver. So Medicaid, you typically think of using in a nursing home or long-term care setting, but there is a program called Medicaid Waiver that basically says, yes, you're sick enough that you could use nursing home level of care, but we're going to waive the requirement that you be in a long-term care setting, and we're going to let you get care in the home or in assisted living. And this can be very, very helpful program. The home care through Medicaid waiver, you could look to get 20 to 30 hours a week of in-home care or some help paying for adult day services. And where usually if you're a single person living in your home, the Medicaid waiver program isn't that helpful for you because you have to be quite ill to qualify for it. And if you're just on your own, other than the 20 or 30 hours a week of care that you're getting, it may not be enough care to keep you in your home. But if you have a spouse who is helping care for you, or other family members or loved ones who are helping in your care, this can be just the amount of care that helps get over the hump so that your caregivers themselves don't become absolutely burnt out. It gives the caregivers time to work a job if they've got a job, or get their own doctor's appointments handled, get the grocery shopping handled, get some respite time for themselves to get some rest. So it can be a very, very powerful program to allow someone to stay in their home. You can also use Medicaid waiver in the assisted living setting. Now, one warning is that not all assisted livings accept Medicaid waiver. So if that's something that you are thinking about wanting to use, you want to make very sure that the assisted living you're looking at accepts Medicaid waiver. We started out with just a very few of them in the Fort Wayne area taking Medicaid waiver, but that number seems to continue to be growing, and new facilities are being built that are large and do accept the Medicaid waiver. And the beauty of that is that if you are on Medicaid waiver in an assisted living setting, you're going to pay the assisted living roughly $800 a month of your income, and the rest of the bill is going to be covered by the Medicaid program. And you're also going to have Medicaid coverage in addition to your Medicare and your Medicare supplement for your healthcare costs. So again, can be a very powerful program. So the thing with Medicaid waiver is that it takes us a little bit of time to work through the process, because the first level is that somebody needs to determine that you're sick enough to even use the Medicaid waiver program. And the agency that does that in the Allen County area and the counties surrounding us is Aging and In-Home Services. And that process takes a couple of phone interviews with the people at Aging and In-Home, where they're going to ask you, hours worth of questions about what you can and can't do to determine whether you meet the level of care required for Medicaid waiver. But the good news is that, 10 years ago when I was working in this area, you might be on a Medicaid waiver waiting list for 2 years before your number got called. Now we can usually get you a Medicaid waiver spot within 6 to 8 weeks. So things are much, much better. The state finally realized that it really is cheaper to keep someone in a home or in assisted living setting versus a long-term care setting. It's where people want to be. So it's a win-win for the state financially. It's a win-win for the individuals needing care. So I would encourage, starting early if you think you want to try to get to the Medicaid waiver program, because it can take us 3 or 4 months to get through everything to get you to that. Now, the beauty of it is when people come to us in crisis, they're in a nursing home, they're getting an $8,500 to $10,000 bill each month while we're doing our work to become Medicaid eligible. And people get very stressed when they're seeing these bills arrive in their mailbox. If you can get on Medicaid while you're at home on Medicaid waiver, the period of time that we're working through the process, you're either spending a small amount of money on a home health caregiver, or you're continuing to limp along as you were the 3 or 4 months prior to you calling us. So while we're doing our work, you're not receiving these huge bills. And if you are on the Medicaid waiver program, you've been approved at home or in assisted living, and your health gets worse and you have to transition to long-term care, we don't have to qualify for Medicaid again. We fax a piece of paper into the Medicaid office and we transition you from the waiver program to the long-term care program. Boom, you're done. And you don't have all that stress of a bill being incurred while we're doing our work. So let's talk about Medicaid in the nursing home setting. And I just want to dispel some myths. People think, well, I don't want to be on Medicaid in a nursing home. And as Jessica said, when people are getting bills of $10,000 a month, most people cannot sustain that for a very long period of time. And I've seen statistics that 80–90% of people in nursing homes are on Medicaid. And I would challenge you to walk through a nursing home and be able to even identify who's private pay and who's on Medicaid. You won't know. Virtually all nursing homes accept Medicaid. There are a few places in Fort Wayne that do not, but most of them do. One thing, most Medicaid facilities, it is going to be a semi-private room. There are a few Medicaid facilities that offer private rooms. And that's just, I would encourage you, if you're, in a nursing home situation, you or your loved one start touring around, seeing what's available, what place seems to suit your personality the best, because you will find that there are places that you feel more comfortable than others. Your personality is going to drive things. But I would not be afraid of needing to use Medicaid to pay for a nursing home. And one other myth is a lot of people say, well, I don't need Medicaid because I have Medicare. And Jessica kind of touched on it. If you're lucky, you'll get 100 days from your Medicare plan and only for rehab. And when I first started practicing, when I was learning this area of law, I thought, oh, everybody gets 100 days. Wink, wink, I'm on rehab. No, it's not that easy. They have very stringent tests that you have to meet to be able to be qualified as a rehab person. And if you have a bad, grumpy day and refuse to participate in your rehab activity, they'll cut you off. I mean, it's real. Or you've progressed to the point where you can't get better. They don't think you can get better. They're going to cut your days. And the Medicare Advantage plans, they tend to offer you fewer rehab days. They may be as low as 20 days. So just don't be afraid that Medicaid is the worst case scenario.
Mm-hmm. So Medicaid, the way I explain it when I first meet with clients is Medicaid has this 3-part test. And the first part is the health test, which Heidi has been talking about both in regards to waiver and nursing home. So then the next part is the asset test. And this is where the numbers can be very shocking for some people. They get a little bit, it's a jarring number because for a single person, the asset limit really is $2,000. Now, a lot of people will confuse this with income and they'll say, well, wait, I have more than that just in, Social Security and pensions. And that is true. A lot of people will receive these funds into their account and the account will swell greater than $2,000 throughout the month. And that's okay, so long as the assets are below $2,000 by the end of the month. But that's still a very low number to live off of. Now, for a married couple, it is a different number. For a married couple, It is a $127,000 limit for the person that is still living in the community. So if your husband is in the nursing home, but you are alive and doing well in your home, and you're still doing all of your own things on your own, you're grocery shopping, you're bathing, you're dressing, you're doing everything on your own, you can have up to $127,000 in assets, but your husband that's in the nursing home can't have more than $2,000. And we'll get in talking to some of those planning things, but not all assets are automatically gobbled up. And that's part of the reason why when we're having these conversations, we're always thinking about that 5-year look back in the back of our minds is, okay, what has been happening over the last 5 years? Did we make these transfers? Were we smart and we started planning really 7 years ago? And so now we really only have a few $1,000s that we're dealing with to get you eligible now that the need is there. And so a lot of times we say it's never too early to start planning and to start having this conversation, because we really do want to know what the assets are and what our long-term goals are, because can we start planning as soon as possible to try to work with these jarring numbers. Now, there are some exempt assets that Medicaid will take off the top right off the bat. And it's very similar to the VA. The first is a residence. However, we don't have that 2-acre limit that the VA has, because what Medicaid will also consider exempt is what we call income producing property. So if you had a 40-acre tract of property and 2 acres of it was really what you considered your home and what you use, but the rest was 40 acres of income producing, Medicaid will exempt all of it for slightly different reasons, but they will exempt all of it. The other exempt asset is a vehicle. It's generally your most expensive vehicle. It will also exempt real estate in the name of what we call the community spouse. This is the spouse that is still in the community and living their normal life. And so a lot of times we will do this with farm ground, with lake property, with second vacation homes, is we will simply remove the name of the spouse that is living in the long-term care facility and have it be in the name of the community spouse. Funerals are exempt for both husbands and wives or just a single person. If you are married and your spouse that is still living in the community has an IRA, those assets are considered exempt. Now, we hear a little bit of hubbub occasionally about them getting rid of that rule, but for now it is alive and well. And so we utilize that a lot when it comes to planning for husbands and wives that have large IRAs. However, we're always also thinking about, especially with husbands and wives, about estate recovery and what happens if your community spouse ends up passing away before the person that's in the nursing home. So a lot of times people will go ahead and get qualified for Medicaid with the help of an outside agency and not necessarily an elder law. Maybe they'll use organizations that really promote using just Medicaid or just applying for Medicaid benefits. You really need to take it another step further and talk to an elder law attorney somewhere in that process, because we are really considering about estate recovery as well as this order of who passes. So if I was the spouse that was living in the community and doing well, I would not want all of the assets to be shifted into my name for me to pass away first and then go to my spouse that's that's living in the facility that we just got qualified for Medicaid. It would really undo all of the planning that we just did. So as an elder law attorney, we're thinking about, okay, what documents do we need to in place to avoid all of that? And a lot of times what we will use is what's known as a supplemental needs trust, like we've mentioned in regards to kids, but really that can be used for a spouse as well. However, we have to do that through a last will and testament. And so that's one of the first things that we're really thinking about, because if something happens to our spouse that's living at home, we don't want them to get sick on us, because we want to make sure that we can utilize this tool. The other things that we're worried about is if you are a single person and you do have this home, what happens to it if I die suddenly? And so right now, what we have been utilizing is what's known as a transfer on death deed. This is a deed that helps avoid probate when it comes to your home. It is an actual deed that is recorded with the recorder's office, and it works very similar to a payable on death or a beneficiary designation. It says that when I pass away, this home is to go to these particular individuals. And at the moment, Medicaid is not attacking these type of transfers. They do have a mechanism to pull that asset, that house, back into the estate. At the moment, we're not seeing them utilize it, but that could always change. And so these are other reasons why we're really wanting to encourage you to talk to an elder law attorney, even if you've already started the Medicaid process, because these are some things to consider beyond just the actual application and qualification.
Yeah, so sometimes, you know, someone working at the nursing home, your assets will be structured such that you can qualify for Medicaid, but they're not people that understand or care about the estate recovery rules or out of order death rules. So just encourage you to see an elder law attorney. So let's talk about just some of the planning options in different scenarios, because everyone, they kind of have heard rumors of the 5-year look back, and they come in and say, well, I didn't plan ahead by 5 years. It's hopeless. What am I going to do? And usually we're the only lawyer that people leave our office usually happy, because we give them good news. So if you are in a married situation where, as Jessica said, one of you is the sick spouse and one of you is the well spouse or the community spouse, through Medicaid planning, and it's not as easy as I'm making it sound, we can usually save all of the assets for the community spouse by transferring them into the name of the community spouse, maybe making a loan of some of them out to a trusted individual who then pays you all of your money back. And at the end of the loan period, the community spouse has all of their asset back, and their spouse is qualified and on the Medicaid program. And sometimes a portion of the institutionalized or the sick spouse's income can be allocated back to the community spouse. So thinking of income as the Social Security and the pension benefit. And where that comes in is that Medicaid sets a baseline level of income of what it says that a community spouse needs to be able to function in the community. And if that person's income level, if the community spouse's Social Security does not meet that level, they will allow a portion of the institutionalized spouse's income to be transferred over to the community spouse. And if you still owe a mortgage on your house, that raises the amount even of higher than what Medicaid's initial number is of what the community spouse is entitled to. So you got to jump through a lot of hoops to get there. I'm making, as I said, I'm making it sound way simpler than it is. And for 3 or 4 months, you will probably not like me or Jessica, who is guiding you through the process and giving you to-do lists of 12, 15, 20 items to take care of, but we will get you there. If you are a single person, again, all is not lost. From the time that you come to an elder law attorney to begin the process, if you're in a long-term care setting, the way that the math works out is that we can usually protect 50% of the assets that you start with, even if we can't get through the 5-year look back. If we have layered in VA, where we could get VA qualified for you, that 50% goes up because we have more asset coming in. And if we started while you were still at home in the waiver situation, either at home or in the assisted living setting, that percentage can then also go up. The percentage of what you can save kind of coincides with how much the care costs. So if you're in a place where it's costing $8,500 a month, we're at the 50% level usually. If we can layer in some VA money, we might get up to 60%. If we can start early in the home setting with waiver, we might get up to 80%. So start early. That's the rule of thumb. All right.
Okay, so we've danced a little bit around this 5-year look back and what it really means. And so one of the things that I usually get asked right away is, well, I've been giving $15,000 a year because that's what the IRS says that I can give. Well, and that is the little bit of bad news that I usually have to share with clients. And that is an IRS rule. And unfortunately, it's not the same for Medicaid. So Medicaid does have an exemption that they do allow, but it's $1,200 per year. And it's not per person like the IRS's $15,000 annual exclusion amount. It is total. So I always give the example of, you've got 12 kids, that's $100 a year. It's not a very favorable rule, but it is the only exemption rule that we do have. So what it means when you really do have this issue of, I gave away $30,000 2 years ago and I need to now qualify for Medicaid, you have a couple options. You can see whether or not that individual may be able to give it back, and then we can make you whole and continue with traditional planning like Heidi described. But let's just pretend that that's not an option. So the worst case scenario means is that Medicaid is going to establish what they call a penalty period. This is a period of time where Medicaid will not pay for your room and board at a nursing home, or if you're at home on waiver, would not pay for home health care. And the way that they determine that, this number changes every single year, but currently it's $6,681. That's a 1 month penalty. So in my example of $30,000, that's, roughly between 4 to 5, 6 months, depending on the exact amount that you gave away, where you would have to figure out how you're going to private pay your expenses. Well, if you started early and we were able to qualify you for the level of care for the waiver program, as Heidi said, we may be able to limp through that penalty period with the family and services that you already have in place, so that by the time you need actual nursing home care or even more at-home care, closer to the 30 hours than maybe the 6 hours, we have already lived through that penalty. And then when the more care is needed, we can jump right in. Now, the other unfortunate thing about this penalty period is this isn't something that you can live through until you've actually made the application. It's either you make it through the 5 years or you apply and you live through that penalty period. There's no way to kind of get it going and say, oh, I don't need the help right now, let's get it going, and then apply or then get full benefits once that's over. Unfortunately, it's just one of those things you have to live through. Any questions about that?
We're about done.
Yeah.
No, I don't see any open questions.
Okay. Well, we would just encourage you to think about your estate and asset preservation planning, because it really kind of cheesy. We say it's a gift you can give those you care about most, but if you've planned ahead and kind of thought through all of the things and already there's an action plan in place at the time that you do become ill, it does make things much easier for your loved ones. So thank you for your time today.
All right. Well, thank you for that informative presentation. I had never considered some of those things, and our lives are constantly changing. So many things to be able to think about. I know I learned a lot. I hope all of you, watching remotely, learned some things too. If your question did not get answered at today's event, Beers Mallers has graciously agreed to respond in a follow-up email to everyone who registered today. We'll send out the video to everyone who registered, so be on the lookout for that. If you would like to view Business Weekly webinars, submit a topic you'd like to see us cover, or you want to find out how you yourself can become one of our presenters, visit us at www.kpceventbuzz.com/webinars. It's www.kpceventbuzz.com/webinars. The webinars are free for Business Weekly subscribers. Non-subscribers will pay a small fee. I want to thank Jessica and Heidi again, and have a great day, everyone. Thank you.
Thank you.